One is Section 63 and one is Section 73AA of the Act. The trial court, my lords, dismissed the suit, finding prima facie A, that the bar under the statutes were attracted. B, my lords, that he had never been able to show possession. C, my lords, there was gross delay on his part, my lords, in filing the suit, because, my lords, it was filed almost 9 years after the date of the agreement. Fourth, my lords, that insofar as the balance of convenience is concerned, this agreement was cancelled by a public notice on 24th of February 2024, and, my lords, the suit was filed on 9th.
The sale transaction had to happen after permission is obtained, isn't it?
Yes. So, my lords, it is our case that the sale transaction itself, my lords, was void on the ground that it was, my lords, without taking permission under both, my lords, Section 63 and under Section 73AA of the Act. Of the Act, my lords. There were two acts, my lords. Your lordship will see.
There are two acts.
Yes, my lords. Page 40, my lords. 73AA of the Gujarat Land Revenue Code, my lords. If the property, my lords, erstwhile belonged to persons, my lords, from certain communities, then, my lords, there was a bar on transfer, because those were grants given to them on account of them being of a particular community. 73AA is at page 14. Now, the High Court, my lords, with the greatest respect, admits the first appeal, my lords, to which I can have no objection. And then thereafter,
But it's again,
it's
the
an
matter is
interlock.
still pending.
It is an interlocutory order, my lord, but the first appeal being admitted will mean, my lords, it puts me back by at least a period of 10 years. My lords, if the first appeal, my lords, it will put me back by a period of 10 years.
No,
And today,
we'll admit it here, and then we'll also say that leave granted at the same time.
that is, my lords.
Yes, heard
But-
Mr. Huzefa Ahmadi.
But there is, my lords, an overwhelming prima facie case in my favor. If your lordship sees the
As
degree.
the first appeal is still pending and the SLP arise out of an interlocutory order, we are disinclined to interfere, the SLP is dismissed.
Can I make one prayer, my lords, only ancillary? Because it's a suit for specific performance. Your lordships are aware that's also a discretionary thing. Would your lordship direct, my lords, the first appeal to be taken? In the facts of this case, I've been litigating.
Why should we earn the curses of all the other first appeals which are pending?
Only for one reason.
No, there can't be. Don't make a submission like that. How many first appeals are pending? What is the statistics? These are of what vintage? And you ask us that you give a direction? Not possible.
Very good.
But we were on keyboard, just my appearance.
Would it help? Would it help?
No, that's a good ground to issue notice.
No,
That's
why
I
kept quiet until the matter is over.
I was consciously keeping quiet.
Sit in the chair. Even he did not sit in the chair meant for respondent, maintaining distance. Feeling of the court.
He was standing.
My learned counterpart had informed me that better don't appear on a lighter vein.
In fact, I was just watching it without saying anything at all, Manoj.
Mr. You are there. If you are there on the respondent side, then
No, but he has taken his chair. He is
No,
already
Manoj.
taken.
That
That
one.
I put them after the order was passed.
Yes.
Right.
Quickly obliged.
Wait.
Also.
65 is over? No. 65 will be added.
I'll consider.
Yes.
In a suit, this is rejection of my plaint under Order 711. After going, the basic infirmity is that the proceedings under Order 711 and the proceedings for interim injunction were heard and decided together, considering the defense of the defendant. And all those documents of the defendants are considered, and the trial court ultimately rejected the plaint and dismissed the injunction application. The matter was carried before the Honorable High Court, and the Honorable High Court also undertakes the exercise of construing various documents on record, on ultimately coming to the finding that I have I am not entitled to the relief. Under 711, the plaint is clearly there on record. My case essentially was that ultimately this was a co-ownership land, and the land was belonging to originally two co-owners. From that land, there was an acquisition which took place for the road. And for that acquisition, both the parties were given, and that is a specific pleading in plain, that both the parties were given equal share in the compensation. ultimately, thereafter, my lord, that land was to that extent, namely 2,400 odd square meters reduced.
Sir, you have been found to be abusing the process of the court.
No, kindly look at note. Honorable court says that this is suppressed by me.
Have they fastened any cost liability on you?
No, well,
I think that is what is missing in the order.
No, what I'm indicating is that the court says that this is suppressed. In fact, not I have mentioned not only my plaint but in my document this aspect. My documents are not considered by the court below. Lord.
We will not.
They are my documents as the plaintiff's documents.
There's a very.
Kindly look at what there are two documents which are produced by me. One sale deed of mine, another sale deed of the subsequent transfer. Those sale deeds are also referred to by me in my plaint. And I have annexed the copies of those revenue records in respect of how the transaction have taken place. Lord. Now, Lord, those sale deeds, the covenants of those sale deeds, also, Lord, there is a clear misreading of the covenants of those sale deeds. The Honorable Court says that because of these covenants, the entire area of land acquisition from for the road has gone from your land. Is nowhere there in my sale deed. Can you look at that sale deed is also there on record, my lord. There is a clear misreading of that document on record, my lord. Look, can you look at the document? That's one of those documents.
Counsel submits that the learned courts misappreciated the contour of exercise of powers under Order 7 Rule 11 of the CPC. Stop. While it is expected that the application filed by the defendant should be considered only at looking at the plaint. Stop. In this case, the defense in the written statement.
Yes.
In the written statement was taken into consideration, and then then the impugn orders were passed. Stop. And what did you say? On the suppression thing, you said something?
I said that for the suppression, I have specifically averred in my plaint both the documents, which London says that these are suppressed. I have averred the extent, the existence of those documents.
Both the said documents.
Both the said documents are referred to.
Counsel further submits on the issue of suppression, the counsel further submits that both said deeds were part of the plaint, and therefore it was wrong to assume that the plaintiff had made any suppression. Stop. Para issue notice returnable in 4 weeks.
But I have annexed the copies of the photographs. They are hurriedly carrying with the construction of on the land in question. But those photographs are there on record. They were there on the record of the court below also.
No, did you have an injunction operating in
that is why I'm saying that trial court heard Order 7 Rule 11 as well as injunction application together and decided also both the things together, and therefore rejection of 711 and that is why exhibit that interim injunction.
The decision of the court to analogously consider the application for injunction and the Order 7 Rule 11 application is also, CPC application is also questioned by the counsel, and it is then submitted that after injunction was refused, the other side is trying to erect structure on the land. What sort of structure?
Their development, commercial complex is
trying to erect structure. What is the stage? We would like to have a look, understand of that.
Now I am told that the construction is now already completed over a period of time. Now for third party interest, there would be allottees on the construction in the commercial complex.
It can't be then that recently it has happened.
No, that's why I'm doing it. During the pendency of the trial court mode, I annexed the copies of the photographs. There the construction was ongoing. Now my instruction is that by the passage of time, it has been over.
That be the case.
I'm sorry?
That be the case, we will not be inclined to pass any interim order. Let notice go.
And how many stories at least we can say that?